Brancatella, and the session does run from 1:15 to 2:30. We're asking you to just be polite. When you have questions, raise your hands. Please silence your cell phones and step out of the room if you do have to take calls, just common courtesy. The exits, of course, are located in the back of the building. And without further ado, I'll introduce you to Sarah.
Okay, hi guys. My name is Sarah Brancatella. I am Legislative Director and Counsel with the Association of Towns. I am super happy to be here today. Before I get started, I'm just going to go over a few things. Number one, you might be like, where is there a handout? Is there a handout for this session? No, because I wanted to work on my PowerPoint up until like 5 minutes ago. So I've been tinkering with it. However, I am going to email it to Jennifer or Felicia. I think that it should be available on the website, on the Tug Hill website afterwards. So you can get a copy of the PowerPoint. I just don't have it in paper form right now. Also save the trees or something, but really I'm just a procrastinator. Number two, I am going to take questions throughout. However, I would ask people to not do the thing where you're like, in my town, this very specific circumstance with lots of details. I'm happy to talk to you afterwards, or if you want to call, I'm happy to talk to you then too, but I just ask that your questions be a little bit more broad, have a broader applicability. Third thing, just a PSA. I like giving ethics sessions, and I like bringing this up in particular in ethics sessions because I think it's a good nexus between the law and what is right and proper behavior. And that is when you are driving on like the 90, the left-hand lane is the passing lane. Okay? When you're done passing, move over to the right. I'm going to set a timer for myself because I tend to ramble on, and I want to stay like fairly on track, and I'm going to put down my Diet Pop. Okay, how many of you are on planning and zoning boards? How many of you are part of your legislative body? All right, okay. I have things for everybody. Some things that I'm going to cover today include common law conflicts of interest. Common law, there we go. Common law is court-created law. So when I'm talking about common law, you have to follow it the same as you would any statutory law, but I can't say, hey, under town law section, or whatever, common law is court-created law. You still have to follow it the same as you would statutory law. Oh, sorry, just one other housekeeping thing. I am going to use the language of towns. I'm going to give it my best effort to say municipalities, local government, things like that, but my bread and butter, my currency is towns. But when I say towns, for the purposes of this presentation, it's an omnibus term. So if you're from like a village or a county or a city, the same rules are applicable to you, even if I'm just saying towns. Okay. Common law conflicts of interest, again, that is court-created law. Miscellaneous General Municipal Law Article 18 provisions. General Municipal Law Article 18 is the only state law on ethics. It's bad. It is a crappy law. It is a crappy article. It has not been updated substantively since the 1980s. There are a lot of holes that exist in General Municipal Law Article 18. And if we're able to get to a certain section, I think that it really highlights where a lot of these holes exist and how things like your local ethics code can sort of fill in the gaps there. But really, common law and common law conflicts of interest, common law case law on ethics evolved so much because General Municipal Law Article 18 has so many holes in it. So courts at some point were like, we have to fill in the gaps here. I'm going to go over some family and nepotism issues when one person can hold two different offices, conflicts of interest in contracts, but that's sort of like we'll see if we get to it because contracts don't come up too frequently in the context of planning and zoning, but if we get to it, we get to it. It's still good to know, and it does come up every once in a while. And then because I'm an attorney and I like to hedge everything, I've got other. So we'll be talking about other things possibly. One thing I'm not going to be talking about, which sometimes in ethics courses generally people ask about, or is the Hatch Act. I'm not going to be talking about that if you've ever heard of it. If you're in office, you're probably good with the Hatch Act. That's all I'll say about that. How many of you got into local government and got on the planning and zoning board so you could pull one over on the residents and get something for yourself? Oh, nobody? Okay, yeah. My confidence in local government is strong. I don't think that anybody gets into local government with the intention of doing something nefarious, doing something unethical. But it's just when you don't know what the rules are. And when I'm talking about municipal ethics or planning and zoning ethics, we all have a code that we live by. Some of us might be religious, some of us might worship at, I still call it Rich Stadium. But yeah, some of us might worship at Highmark Stadium every Sunday, or for at least 18 weeks out of the year. But we all have our code that we live by. That is not what I'm talking about when I'm talking about municipal ethics. I'm not talking about things that like in the world seem good. I'm talking about objective principles that define behavior as correct and right. A good example of what I'm trying to say is like speeding isn't inherently bad, right? But you can be speeding because you violated the speed limit. There's nothing inherently amoral about it. So ethics are like these objective principles by which you should live. We're not talking about moral issues. And ethics laws can act as both a sword and a shield. I'm sure that some people have had people come to your meetings, come to your public hearings, and maybe you were actually the resident gadfly who came to meetings and said, you guys are up to something shady. The town is up to something really, really shady here. I don't know what it is, but I think that this is wrong, right? Ethics laws allow you to say, you know what, I've actually complied with my legal responsibility. I've done what I'm supposed to do. I understand that you might have a difference of opinion in this, but in the words of the dude from The Big Lebowski, that's just like your opinion, man. I'm doing what I'm required to do under the law. So it acts as both a sword and a shield, because obviously also ethics laws are supposed to protect the public from avaricious officers and to protect innocent public officers from unwarranted assaults on their integrity. So it serves both purposes. It's not just a tool to needle people who are into public service and are actually on their planning and zoning boards. It's also to protect you. So what are these objective ethics sources that I'm talking about? Again, General Municipal Law, Article 18, the only state ethics law that exists. Significant issues with it, significant shortcomings, and most of ethics for planning and zoning actually is going to come from common law. And that in and of itself is a statement on how defective, derelict, insufficient is the word that I want to use, how insufficient GML Article 18 is. Again, common law, as I said, court-created law, it tries to fill in some of the gaps that exist in Article 18. Your local ethics code, every municipality is supposed to have a local ethics code. You're required to have one. It is a wonderful opportunity to clarify what behavior is appropriate and what you should do under in certain circumstances. I'm getting a little bit ahead of myself, but just as an example, there's no definition of what constitutes recusal. The state doesn't define that. You know what could define that? Your local ethics code. All right, it could say that recusal involves removing yourself from conversations as soon as you know that a conflict of interest exists. Because I cannot tell you how many times I have people call and say, you know, such and such said that they recused themselves, but really they were just engaging in conversation up until the point of a vote. And then they were like, oh no, I'm recusing myself. I'm not a part of this process. If you have a definition of something like recusal in your local ethics code, that it's just a great tool. It's a great opportunity to fill in and clarify some things as far as what behavior is appropriate. Agency opinions, those are opinions from like the Comptroller's office and the Attorney General's office. Those are not the same as common law in that you don't have to follow them. They don't have the same effect as common law or statute, but what they are is a great canary in the mine, right? It's a good indicator of how a court could possibly rule. Also, I think The real value lies in when you have that gadfly come to your public hearing, come to your meeting, you can say something like, hey, the Attorney General's office looked at a comparable situation and they said that there was no conflict of interest here. It creates a rational basis. So again, you don't have to follow it, but they are great sources just to sort of like check in, take the temperature of an issue. Local ethics boards, I love local ethics boards for a few reasons. Something that is really important to keep in mind with any sort of municipal ethics is that reasonable minds can differ. Okay, I dated somebody for like 11 years. He had one opinion on what I should spend on shoes. I had another opinion. We were both actually super reasonable. I was right though. But reasonable minds differ a lot in ethics. Also, there are so many gray areas. If you're coming to this class hoping to get a clear, like, yes, and then I'll know yes here, and then I'll know no here, you might want to go to like the case law update instead next door, because there are still going to be these gray areas that exist in ethics. And what I love about ethics boards is that you have a meeting of the minds, like 5 different people come up with one decision. I can't tell you how often in my office I talk to the other attorneys, and we'll go back and forth. We might have differences of opinions, but with an ethics board, you have 5 people coming up with one determination. It's really a vetted opinion, a vetted process. Other ethics sources, talk to your town attorney, talk to other people who have been in your position, talk to your fellow board members, take the temperature of people who have been in your position before. Also, you can always call the Association of Towns, or if you're a city or village, NICOM, amazing resource, or if you're from the county, NISAC, incredible, love those guys too. So each type of municipality has their own association, and you can always call them to ask for, ethics information, let's say. All right. Getting started with like the nitty gritty. I keep saying getting started and I'm already like 15 minutes in. Anyway, no, really getting started. To determine if a prohibited conflict of interest or ethics issue looks, I always recommend looking at GML Article 18 first, your local ethics code second, and then common law. One of the reasons why I suggest starting with Article 18 is because if you're in a contractual situation, you just can't enter into the contract if there's a violation, if there's a conflict of interest under Article 18. Other things that Article 18 covers are gifts, and I'm going to go over that later, compensation on matters before an agency, and financial disclosure statements. So this seems like not a very comprehensive list of what's in Article 18, right? Seems kind of puny, seems insufficient. That's because Article 18 has a lot of gaps. These are the only things that it covers. As I said, it covers conflicts of interest in contracts, but if you're on the Planning and Zoning Board, what about a land use application? Land use applications are not considered contracts under Article 18. Therefore, it automatically takes them outside of the Article 18 conflict of interest analysis because you're not dealing with a contract, and Article 18 only deals with conflicts of interest in contracts. So that is what I meant before when I said most of planning and zoning ethics is a result of common law, because courts have taken a look at situations involving planning and zoning boards and said, I know that technically you might not be violating a statute, you might not be violating Article 18, but we still think that these are the circumstances where somebody should recuse themselves, or where there could be an issue. I have a 6-part question on how to analyze if there is a conflict of interest, and it starts with, does the potential conflict lie with a contract with the town or municipality? Again, land use applications aren't actually contracts under Article 18. So you immediately don't even have to ask those first 4 questions. You just go to questions number 5 and questions number 6. Does your local ethics code apply? And is there a common law conflict of interest? And that is when you are dealing with a land use application. And don't worry, if we have time, I'm going to go into excruciating detail about those 4 questions on analyzing a conflict of interest under GML Article 18. But since this is planning and zoning focused, we're going to start with common law conflicts of interest. And sometimes people refer to it as an appearance of impropriety. I personally do not like that term, and I'll tell you why. Because the appearance of impropriety doctrine, or common law conflict of interest, where courts were like, GML Article 18 sucks, let's try and fix this through common law. Case law, as it's developed over the last 40-some years, has really strayed away from focused on if there's an appearance to whether there might actually be one. So I don't really like the phrase appearance of impropriety because the seminal case that it comes from, there's language, government officials must maintain public confidence in the integrity of government. They must avoid even the appearance of impropriety. It is the policy of the law to keep the official so far from temptation as to ensure his unselfish devotion to the public interest. That is very lofty language that doesn't give a lot of clarity. And it seems like pretty much almost anything would be a conflict of interest then under common law standards. It comes from this case from 1979, the town of Tuxedo. And in this incident, in this case, you had Company A had applied to build a really controversial project. It was 4,000 residential unit project. The town board had delegated the environmental impact hearing responsibility to the planning board, but they retained final authority over that. So planning board, the town board was like, okay, planning board, we want you to do like the grunt work and then we'll actually just make the final decision, right? So planning board was responsible for doing the environmental impact hearing. At that time, the town board was split 3-2 in favor of the project, but they couldn't move forward until the planning board had completed this hearing. What happened? What time of year was it? It was an election year, okay? And it was around November. So what happened was the November elections happened, they took place, and the people who were voted into office, all of a sudden, the board switched. Now it was 3-2 against the project. So you have this lame duck town board, right? And they're like, okay, we're gonna do everything that we can before January 1st comes to get this project through. So what they did was between the November elections and the end of January, the town board adopted a local law being like, actually, just kidding, planning board, we're not gonna give you this responsibility to hold the hearing. We're gonna hold the hearing, we got it. And then, and they did this even though the DEC was like, hey, could you guys wait? Could you just not do this? So it was really clear the chicanery that they were engaged in. Everybody knew what was up. And then on December 28th, the town board approved the project. One of the voting members of the town board was the vice president of an advertising agency that did a lot of business with the applicant who was doing the 4,000 unit residential project. Okay, this is one of the lame duck town board members. Technically, this doesn't violate anything under GML Article 18, because we're dealing with not a contract, guys, not a contract, land use application. So the court said, technically you didn't violate any laws, but you know what? That doesn't sit right with us. It requires no feat of mental gymnastics to infer that if the application is approved, the agency will be a strong contender to obtain all advertising contracts in the $200 million project. Again, $200 million in 1979, too. So the court invalidated the vote, even though technically the town board member didn't violate any statutes. They said that the town board member violated the intent of the law. And that is the first case where courts have tried to develop a common law case law on ethics and fill in some of these gaps that exist in Article 18. So that's where we started, and we'll see where we're going. Common Common law conflicts of interest, as I said before, apply to more than just contracts. Unlike GML Article 18, it applies to all public officials and all employees. And then I have, for example, a variance application, not a contract, but it would be subject to common law conflicts of interest. I include this slide and I refuse to get rid of it because this is my magnus opus in terms of art and technology skills. So I drew those two circles. And you can see with the computer, you can see that common law conflicts of interest cover a lot more than GML Article 18 conflicts of interest. With the lofty language about it is in the public interest to avoid, such self-interest, blah, blah, blah. How do you actually evaluate common law conflicts of interest? After reading through, and I'm not kidding, every single case that has come out since 1979 on municipal ethics, I recommend breaking it down into two questions. Number one, is the interest personal? And number two, is the interest substantial? Question number one, if you have a land use application before you and you're like, is there a conflict of interest here that I should recuse myself? First question to ask, is the interest personal? And an interest is personal, it's specific to you. It's not one that you share with the public generally. And there are a couple of cases that really highlight this principle. So we have Troy Sand and Gravel. You will be amazed at how many cases involve gravel mines. I have like 4 of them in this presentation. Apparently it's a hot, litigious subject. But so in this case from 2017, the town board had maintained jurisdiction over a special use permit application for a gravel pit. One of the arguments that the challenger said in court was that the supervisor should not have voted on the special use permit because he owned property near the gravel pit. And the court said the location of real property owned by the supervisor and his family near the site of the proposed quarry is an interest that the supervisor has in common with many other citizens of the town. So it's not something unique and specific to them, because if you are a public official, you also are a normal person. Okay, you wear 2 hats. And you don't give up your hat as a resident just because you are a public official. And yeah, owning property here in this instance, if he were the only person, if the supervisor were the only person who had property by the gravel pit, that would be different, okay? And a lot of times ethics decisions, ethics determinations, really, they're so fact specific, and little details like that can change the answer. So that's another reason why sometimes people don't like ethics, because you can't really paint broad brushstrokes with it. That's why I like it. I live in the grays. But yeah, if you were the only person around there who had a piece of property by the gravel pit, that would probably be different, right? That is something that is unique and individual to the supervisor. But here, because other people had property by the gravel pit, it was not a personal interest. And so there was no conflict of interest with regard to that argument. Him owning property didn't cause any issues. Another case, also involving, weirdly enough, gravel and mining, is Byer versus the town of Potenskill in 1996. And here, the town board had voted on a local law allowing mining in residential districts, in certain areas of residential districts, and the town board member owned property in a residential district that potentially could be suitable for mining. He didn't have a permit. He had nothing in place being like, okay, I'm gonna mine this. He just simply owned a piece of property in a residential district, and property in this residential district was going to be impacted by this zoning local law. And the court said, every owner of property in a residentially zoned district is affected by this local law. This interest is not personal and specific enough to you to warrant, for there to be an issue here, for there to be a conflict of interest here. So really, when I'm talking about, is the interest personal, very specific and unique to you? So that's the first question to ask. If you're looking at a land use application and you think to yourself, should I recuse myself? Number one, is the interest personal? That one is way more easy to identify than the second question that you should ask, which is the interest substantial or more than speculative? And here is where a lot of gray exists. And here also is where you get things like family issues and issues of bias, when somebody can speak out, when somebody has an opinion on something. And this all falls under, I think, the second question of, is your interest substantial? Have you done enough? Is it more than just we think that there might be a problem sometime? And substantial is the interest substantial is difficult because it's not always a quantifiable term. Starting off with a case where there's a quantifiable thing, generally courts are going to find the interest is substantial if you have a financial interest in it. This is a general rule, and I'm going to highlight my favorite case of all time out of any subject, and it is the town of Parker versus the town of Gardner. And here you have a planning board chair who owned a steel supply company, and the steel supply company had a contract with the applicant before the planning board. Over a 2-year period, the planning, so I just want to make sure that everybody understands the construct here. Okay, you've got like the planning board chair owns the steel supply company sometimes does business with this entity that is appearing before the planning board. I hope that my hand gestures helped clarify that. But the court, actually, I'm going to take a survey here. So how many people think that the planning board chair has a conflict of interest here and should recuse himself? Okay, I see some hands. And remember, this isn't all that different than what happened in the town of Tuxedo case, right? It was the guy, he had an advertising agency. It could do business with the applicant before the board. Over a 2-year period, the business with the applicant constituted 0.15% of the planning board chair's company's revenue. And I said, what about the town of Tuxedo case? What I love about this case, it went to the ethics board. That is not my alarm. Okay, it went to the ethics board. The ethics board was like, hey, you know what? We think 0.15% of, like gross sales over 2 years, we don't think that's substantial enough. We think that's a de minimis amount that is unlikely to influence your ability to remain impartial. Somebody wrote to the Attorney General's office. The Attorney General's office was like, oh no, it is the policy of the law to have such unselfish devotion, quote Tuxedo, quote Tuxedo, quote Tuxedo. Okay, so they were like, yeah, there's this case. No, there's definitely a conflict of interest here. It went to the Supreme Court, the trial level court, and the trial level court said, we think that there's a conflict of interest here. It went to the appellate division, and the appellate division said, let's look at the very fact-specific things in this case. 0.15%. Does anybody want to guess how much that equaled for this guy's company? You know what, I'll just tell you. It was about $2,000. So the court said 0.15% over 2 years, like $2,000 over 2 years, is a de minimis amount. It is unlikely to impact the planning board chair's ability to remain impartial. This is quite a difference from the town of Tuxedo case, right? And you can see how case law develops. And that's why I don't like to call it the appearance of impropriety, because it's developed over the years. Also, let's say it was 0.15% of the Coca-Cola company. That's going to be a heck of a lot more than $2,000, all right? That is going to make it more likely that a substantial interest exists, warranting, creating a conflict of interest, warranting recusal. So, general rule is, if there is a financial interest, a court is more likely to find that your interest is substantial. Financial interests more likely to be substantial. However, not always. So another reason why I like ethics is because if people ask me questions, I get to be like, I don't know, what do you think? There's so many gray areas. as I said too, substantial is not always a quantifiable term. It's not always going to be dollars and cents, right? I have up here, relationships are scary, and a random picture of my cat, because I love my cat. And if you're not having fun, you're not doing it right. So an example of this would be a neighbor of a planning board member applies for a special use permit. The appearance of impropriety, or if there is a common law conflict of interest warranting recusal, depends on the circumstances. It depends on if that relationship is substantial enough. Okay, you might be able to tell from my flat A, or you've heard me talk for more than 5 minutes before, I'm from Buffalo. I was born and raised in Buffalo, very proud Buffalonian. I live in Albany now. It's not Buffalo. Let's say my neighbor is also from Buffalo, and all of a sudden we become best friends because we both love the Bills, all right? And every Sunday we cook a lot of food, we watch the Bills, we have a great time, we talk about Loganberry and sponge candy. You know, we're like, Tragically Hip is amazing. So we really bond over being in Buffalo. And I'm on the planning board because I have a close relationship with him or her. Kind of tips the scale towards maybe I should consider recusing myself. Is the relationship substantial enough? On the other hand, what if it's a neighbor who lives a mile down the road? I know that they generally exist. I know that their lawn is well kept. Sometimes I might wave, but I'm generally misanthropic, and it's way more likely for me to do this and be like, okay, I'm not going to talk to anybody. Then that tips the scale more likely towards the relationship is not substantial enough to warrant a recusal. So it's not the fact that somebody is a neighbor, all right? Just the fact that he's a neighbor does not automatically create a substantial relationship. You have to look at the facts and circumstances, the particular things of that circumstance. A great case, another one of my favorite cases, that covers when a conflict of interest under common law would be substantial enough, or when, I should actually say, when something isn't substantial enough, because especially in rural communities, you're gonna know everybody in the town. You're gonna know everybody in your municipality. Everybody might be your in-law or cousin by some degree. And yeah, it's not all relationships are going to be substantial enough to warrant a recusal. And I like this case and the other example that I have coming up too. And you have DiPaolo versus the town of Ithaca from 1999. And here, Cornell University had a bunch of proposed projects that did not involve a gravel pit, actually, but it involved lake water. Anyway, Cornell University had a series of, a proposed project that needed a series of permits and wanted some rezoning done. On the town board in the town of Ithaca, you had a town board member who was, ooh, that is my alarm. 2:30? Do we go until 2:30? 2:30. 2:30? Okay. Yes. 2:30? Okay, great. Okay, sorry, I just wanted to keep on track generally. Anyway, in the town of Ithaca, you had a town board member who was married to somebody who was retired from Cornell University, and they received pension benefits as a result. You also had a town board member who was a graduate student at Cornell University. And the person who was challenging the actions of the town board with respect to the rezoning and with respect to the permits, they said that there was a conflict with both of these members. The court took a look at it and said, okay, the person who's married, whose spouse receives benefits from Cornell University, those are in a fixed amount. They are not going to be increased or decreased if this zoning gets adopted or doesn't get adopted. Therefore, we do not think there is a substantial enough interest, right? They were like, here, there is no financial interest, and otherwise, there was no financial interest, and that's really what they focused on. And just the fact that they were married to a retiree who had nothing to do with the project was not substantial enough. With respect to the town board member who's also a Cornell graduate student, the court focused on the fact that it was an entirely different program that was applying for these permits and for these rezoning. I mean, think of it as like the graduate student was in like philosophy, and it was the physics department that was applying for these things, right? There was no nexus between the two of them, and the graduate student stipend would not be impacted by. So again, you have like these relationships. These town board members had a relationship with Cornell University. However, it wasn't substantial enough to create a conflict of interest. And no, too, these are particular, the interest was personal here, right? It's like a unique circumstance to those individuals. So the question was it substantial enough? And the court said no. Probably my second favorite case of all time. You have a petitioner who claimed that there was a conflict of interest on the Zoning Board of Appeals with board members. There was a board member and his wife taught the applicant's daughter piano and got a Christmas present. All right, the piano teacher got a Christmas present. So the petitioner here was like, oh no, there's a relationship. The wife of the ZBA member, teaches piano to the applicant's daughter. Also argued that because the mother-in-law of one of the ZBA members spoke out against the project, that was also a conflict of interest. The court said, verbatim, it was mere speculation. It wasn't substantial enough. The subtext to that was like, are you kidding me? That's insane. Also, who has that amount of money to just bring these lawsuits? So yeah, not every relationship is going to be substantial enough. You guys live in your community. Okay, you interact with people. Not everything is going to rise to the level of substantial. Don't worry if in fact you are the piano teacher in that scenario too. Seems unlikely that that would impact somebody's ability to remain impartial. Substantial relationships, that's also where issues with family come into play, right? Because presumably with family, you have a substantial relationship. And that's why it's sort of axiomatic to be like, well, if you're on the planning board and your sister appears before you, you should probably recuse yourself, right? That's probably a substantial enough relationship to warrant recusal. However, I want to be clear that just because familial relationships exist, doesn't mean that it's automatically substantial, okay? People's families are different. I have first cousins who I would not be able to pick out of a lineup, all right? I'm not saying that as an indictment on my family, I'm saying that as a reality. So if I'm on the planning board and my first cousin, I might realize 2 weeks later that it's actually my first cousin appearing before me. You have to be focused less on titles and more on the substance of a relationship. Also, when it comes to family, and this kind of falls under common law conflict of interest, but I think it's just a good place to talk about it anyway. It was members of the same family working for the same municipality. This happens a lot. So the general rule is that an officer or employee should not participate in decisions concerning the salary or terms and conditions of employment for other families also employed by the municipality. A perfect example of this would be a wife on the town board and the husband is the highway superintendent. In that instance, she should recuse herself from voting on the highway superintendent's salary and any sort of benefits that he might receive. She could vote on and participate in discussions on highway budget matters generally, but when it comes to the highway superintendent's salary, because there is a substantial relationship, it is her husband, she should recuse herself from voting on that, on his salary, but can vote on the highway budget as a whole, because the highway budget as a whole is it's not particular and specific to the highway superintendent. Even as I'm saying those words, I'm like, that doesn't sound very true, but that's generally the idea behind it. Something that you can do in your town ethics code is, as I said, there's no state rules on nepotism. There are no state rules on family members. Something that you could do in your local ethics code is define and have a provision on nepotism. And here I have an example where In this policy, every public officer and every municipal employee related closer in degree by blood or by marriage than first cousin to any people seeking employment within any department, section, or function of the town shall disclose such relationship. So basically what this policy says is that if you are related by more than first cousin or closer, you should, and somebody applies to the town, somebody wants to get appointed to the board, you just have to disclose that fact, okay? You just have to disclose that fact. So what happens, an example of, let's say Linda, which is my mom's name, is on the town board. Her husband, Vincent, my dad, applies to fill a vacancy on the Zoning Board of Appeals. What should Linda do using this nepotism policy and common law standards, right? Number one, is the interest personal? Like, is it unique to her? Sure is. It's her husband. Number two, is the relationship substantial? Sure is. It's her husband. And then, under the nepotism policy, it requires Linda to disclose the fact that Vincent is her husband and she should recuse herself from voting on his appointment. Does that make sense to everybody? Okay. What about, let's change the scenario a little bit. Carrie is on the town board. Carrie's my sister. Her long-term boyfriend, Kent, who's, now that I'm telling you all about my personal life, Kent is actually my brother-in-law, but when I wrote this example, I still keep him as a long-term boyfriend. Carrie is on the town board. Her long-term boyfriend, Kent, applies to be on the Zoning Board of Appeals. What should Carrie do? Applying the nepotism policy, she doesn't need to disclose it under this nepotism policy. It's her long-term boyfriend. It's her, and this only applies to people related in closer degree by blood or by marriage, right? You know, living in sin, don't have the legal document saying that they are married. So this, technically, she would not have to disclose the fact that Kent is her long-term boyfriend. However, let's apply common law standards, right? Because as I said, when you're looking at land use applications or things like this, the first thing to ask is, the first thing that you want to look at is your local ethics code. So we did here. The nepotism, the local ethics code doesn't apply. So then what are the common law standards for, is there a conflict of interest? Is the interest personal? Sure is, right? Unique to her. Is the interest substantial? I don't think there is a colorable argument to say no, right? So what Carrie should do in this instance is recuse herself. Let's say that they had only gone out on one date. Is that substantial enough to warrant Carrie to recuse herself? Was he a jerk? I mean, reasonable minds can differ on that, okay? Like, some people might be like, oh, yeah, especially if it was a bad date. You know, maybe you do want to recuse yourself. But I think that's a great example of how little details can change the outcome, and reasonable minds can differ. And if there are situations like that and you're like, ooh, I'm on the fence, I don't know if this is a substantial enough relationship to recuse myself, ask people, ask your fellow town board members, ask your municipal attorney. Take the temperature of the town. Is it a really, really controversial topic, right? You know, are you inviting litigation on this? These are all things that you have to take into consideration. By expressions of personal opinion, sometimes bias and expression of personal opinion can rise to the level of a substantial enough interest. And I have 3 confusing cases that I'm going to go over, and you're going to be like, I don't know, based after this, but it's just also a byproduct of the case law on this is all over the place. So it's, if you're like, I don't know what to do after this, and you're still a little bit confused, I'm not saying that you're in good company, but I'm in that company. So as I said a couple of times now, even though you are a municipal official, you are also a person. You are also entitled to have opinions and, care about things in your personal capacity. However, there may be perceived or actual conflicts if you are sitting on a board reviewing that application and you have expressed an opinion on it. The reason why this is particularly important with land use applications is because it is a quasi-judicial function. You are supposed to make that determination based on the record in front of you, not on your personal opinions, not on anything other than the four corners of the record in front of you. You're supposed to kind of view it in a vacuum and just be like, here are the documents in front of me, here's what they said at the public hearing, that's what I'm making my determination on, not my personal opinion. So that is why expressions of bias or personal opinions can sometimes rise to the level of substantial. Yes. And I didn't even go over my cases yet that are going to confuse you, but yes.
What's your opinion on a planning board member attending the zoning board appeals meeting and rendering, as a citizen, rendering opinion, or vice versa?
Okay.
The planning board's dealing with a special use permit, let's say, and a zoning board member chooses to attend the meeting and speak on the project.
Okay, so the question was, what is my thought on if, let's say that a planning board has a special use permit application before them, and what about a member of the zoning board coming and speaking as a resident? Does the zoning board have any jurisdiction over the special use permit? Do they have any role involved with it? Probably not. So that, because the zoning board has nothing to do with the special use permit application, assuming that's correct in this instance, there's nothing that would preclude a zoning board member from going and speaking up as a citizen. They are not the ones who have jurisdiction over that land use application. But let's say, and this segues nicely into this case, let's say that you're on the planning board, you have a special use permit application before you, and you want to speak up at the public hearing in your capacity as a resident. What do we do then? So here, in this case, I'm not even going to pretend to pronounce the name, involving the village of Caledonia, the court found that there was an appearance of bias substantial enough when two village planning board members signed a petition supporting a project, and the project had an application pending before the planning board. It also said that there was actual bias when one village planning board member signed a petition and wrote to the mayor supporting the new project and explaining why she personally supported the project. So here the court found that these expressions of opinion, while there was an application pending before the board, was substantial enough to create a conflict of interest, and they should have recused themselves. If, I'm going to say this again, if there is an application before you and you want to speak up on it, you should probably recuse yourself, okay, if you have an application pending before the board. I'm not going to, that's not a hard and fast rule. I guess my rule would be tread lightly, okay? If you have an application before your board that you are reviewing and you want to take a position on it as a resident, you have an opinion on it, you want to sign a petition, you want to do something like that, tread very lightly, okay? Yes, question.
When you recuse yourself, you can't recuse at the vote. Don't you have to recuse yourself then before you even talk about the application, when the application is started? Right?
Okay, so the question...
You can't be in the whole process and then say, well, I'm recusing.
So the question was, when you recuse yourself, shouldn't you remove yourself from the conversation, totally, not just the vote? So again, there's no definition for what constitutes recusal in the law. So you get a lot of times people who are like, I recuse myself, but they continue to participate in conversations and then just don't vote. That's not great. Okay, that's not great, but that is where you should use your local ethics code to further clarify what is required under recusal, because then in your local ethics code you can say, get out of the room, guys, like stop talking. Another case, and we're going back to Byer versus the town of Potenskill, because especially with like ethics cases, there are a lot of different arguments for why things are unethical. So you had another town board member, if you recall, this is another gravel pit case, and Here you had a town board member, before becoming a town board member, he got a permit to mine part of his property. If you recall, this is the case where the town board was evaluating a local law on if you could mine in residential districts. There was the one town board member who had property in a residential district, and just by virtue of that fact, he did not have a significant enough, or it was not personal to him. And now we have a different variation on it, same case. It's the residential gravel mining local law, but it's a different town board member. And before becoming a part of the town board, they got their permit to mine part of their property. Also, before becoming a town board member, they spoke out against a local law prohibiting gravel mining in residential districts. After getting elected to the board, he voted on the local law allowing mining in on residential property. The court said that there was no conflict here. The fact that he spoke out against the project before he was in office did not create a substantial bias. And actually, it would have a chilling effect on somebody's ability to campaign. Campaign opinions are different than when you are in office. And the court here did not want to gag a candidate's ability to create a campaign platform or offer an opinion on something that was important to the town. So campaign speech, here's a takeaway from this one, campaign speech is different. You can offer a position on something if you are an elected officer as part of a campaign, but once you become once you're part of the office and you have a land use application before you, again, quasi-judicial function, you are supposed to make that determination based on the record. Local laws, which is what we're dealing with here, you don't have to make a decision based on the four corners of the record. You don't have a record before you, right? So expressions of opinion on local laws are less likely to be a substantial expression of bias. Does that make sense? So you've got your land use applications where you're supposed to make that determination on the record in front of you. Then you've got somebody who might offer an opinion on something before they become a member of the board. Okay, that's cool. What are we gonna gag everybody in the municipality so that nobody can offer an opinion? Because I think what the court said is that it would basically render everybody ineligible to hold office then. So if you've expressed an opinion on something, you're on the planning board, you're on the ZBA, before you got into office or before you took your position, that's cool. If the application is before you, don't say anything. Keep your opinions quiet or speak in private if you are on a planning and zoning board, particularly if there is an application before you, because that is more likely to be considered a substantial expression of bias. We have yet another gravel pit case. And here you have an individual had spoken out against the gravel pit project at a public hearing. Later on, they were appointed to fill a vacancy on the planning board, and they voted to approve a master plan that eliminated the gravel pit, allowing the gravel pit. And the court said that there was alleged bias only involved personal opinion rather than financial interest. So again, this is like a weird little twist on it here where a court is super focused on well, is there a financial interest if you're just expressing opinion? But you have the case with Caledonia, with the Village of Caledonia, where they were just expressing opinion. They didn't have any financial interest in here. But I think the difference here too is that in the Village of Caledonia case, you had currently sitting planning board members when they were expressing that opinion. In this case involving the town of Amenia, you had somebody who expressed an opinion before they got on the planning board. And therein, I think, lies the difference. But I did want to point out too that the court was focused on the fact too that they didn't have a financial interest. It was just an expression of opinion. So Common law conflicts of interest. In general, courts will find if there is a financial or material benefit involved for a public officer or for one of their family members, it is more likely to be considered a substantial interest. But there's that Town of Gardner case with the 0.15% and the steel supply company. Just because you have a financial interest doesn't automatically mean that it's going to be substantial. There is generally like a de minimis. If it's such a small amount, if a court believes that it is such a small amount financial, such a small interest, it is not substantial and will not impact your ability to remain impartial, generally courts will not find a common law conflict of interest. The Attorney General's office advises officers to recuse themselves when there is an appearance of impropriety or when there is a common law conflict of interest. It recommends, again, these are recommendations, recusing in public and on the record, and it suggests that recusal prohibits you from discussions, deliberations, and voting on the matter. Again, I've said this like 3 times already. Take a look at your local ethics code. I think that is such a prime opportunity to define what constitutes recusal, removing yourself from the entire conversation. And that is really supposed to be the difference between recusal and abstention. Abstention is just like, I'm not going to vote on this immediately. Recusal is disengaging from the entire process so that you don't spoil it. Also, recusal is a personal decision. Nobody can force you to recuse. There are consequences for acting despite there being an appearance of acting despite there being a common law conflict of interest. But one thing that's not necessarily a consequence, it is a consequence, I guess, I want you to keep in mind when you're deciding if you're going to recuse, is that a recusal is always going to have the functional equivalent of a nay vote. What do I mean by that? Let's say that you have a 5-member board. 2 people vote yes, 2 people vote no, 1 person recuses and doesn't vote. That vote is never going to be counted as a yes. All right, it's never going, I mean, there are issues on planning boards with like tied votes and all that. Yes, I'm aware of like case law on that, but it's never going to count as a yes. It will, in form and function, be counted as a no. So that's something that you might want to take into consideration before you decide to recuse. What are other consequences of acting despite there being an appearance of impropriety? Litigation, right? Especially, so I clerked at the 3rd Department when I got out of law school, and I realized that I was working on a lot of cases involving private easements on lakefront property, and my boss at the time was like, nobody loves to sue more than Adirondack property owners. And I'm like, yeah, okay, yeah. Second homeowners, right? Very litigious. So litigation, a consequence, all right? You acting despite there being a conflict of interest could actually sink the entire ship, you guys, okay? With great power comes great responsibility. And that's, yeah, be mindful of that. Be good to the people that you work with. I can't tell you how many times I get phone calls where there's an obvious conflict of interest and a board member is freaking out about it. And I'm like, that's really their personal decision. Sorry, that stinks. The action could get voided in court. Also, for planning and zoning board members, you could get kicked off the board. There is a procedure in the law to remove a planning board and a zoning board member. It requires, there has to be a reason. It can't just be for political purposes or because I don't like the way that you voted on a certain thing. But if you voted on something despite there being a common law conflict of interest, that is grounds to have somebody removed from office. So that is something important to keep in mind if you are on the planning and zoning board. You could get removed if you act despite there being a conflict of interest. You would be entitled to an administrative type hearing beforehand, but that might just be embarrassing if you acted despite there being a conflict of interest. So that is common law conflicts of interest and evaluating that. I'm going to shift gears a little bit and talk very briefly about gifts. And general municipal law, this is one of those like random statutes in general municipal law. Section 805-A says that a public officer or employee cannot solicit or accept gifts more than $75 that could reasonably be inferred to influence official duties. You can reduce this amount in your local ethics code. I don't recommend reducing it to 0, and I say it's the chocolate bunny problem. There was a town in Chautauqua County, and they had reduced the amount, the gift amount to 0 in their local code, and a vendor had sent them a chocolate bunny for Easter, and the town clerk was like very by the book, and she ended up spending more money sending the chocolate bunny back to the vendor than the chocolate bunny was actually worth. So I don't recommend having 0. Also, what does could reasonably be inferred to influence performing official duties? Again, you all have 2 hats. You are a public official and you are a person. If your friend gives you an $80 bottle of wine, invite me over. I will give you my email address. Okay? But that is not a circumstance. It's not reasonable to think that a friend that you have a relationship with, that you've been pals with for years, is trying to influence your official duties on the planning or zoning board. On the other hand, if you have an applicant and all of a sudden they want to take you out for a round of golf. Oh, gee, we just thought we'd buy, Panera lunch for the board today. Isn't that nice of us? Do you want some for refreshments at your public hearing? Oh, guys, be wary of that one, okay? That is more likely to be considered, more likely where it could reasonably be inferred that it is going to influence your official duties. The reason why I'm so openly disdainful of that language, in case you couldn't tell by my face and intonation, is because there's at least one court case that says that the language is unconstitutionally vague, and I just think it's another provision of GML Article 18 that really needs to be clarified and fixed, but this is the language that we're stuck with for now. What are the consequences of acting, or what are the consequences of accepting a gift over $75 that could reasonably influence your opinion? Sanctions, fine, could be grounds for removal, again, if you're on the planning or zoning board. Also, even if you don't have a substantial interest, you are under General Municipal Law, Section 809, under land use applications. If you have an interest in a land use application, if you know somebody, right? If you're like, oh, this is my first cousin, even though I even though I couldn't pick them out of a lineup, the law says that you should disclose. You should disclose, particularly when you have a financial interest. And again, all financial interests are not automatically going to be substantial enough to create a common law conflict of interest, but you should disclose the fact that you have that interest in the first place. There's another provision in General Municipal Law, oh my gosh, I actually didn't put the citation there, but I'm pretty sure it is 803, General Municipal Law, Section 803, and it prohibits municipal officials from receiving compensation for matters before their board. A perfect example of this would be a planning board member who is an architect is prohibited from acting as an architect on projects appearing before the planning board. All right, they are getting compensated for a project that is appearing before their very own board. Even the Attorney General's office says that uncompensated work should probably warrant recusal. Even if you're just doing it on a volunteer basis, it's not a bad idea to recuse yourself. And you have this case, Keller v. Morgan, and here you had the chairperson of a planning board, had a 25% interest in the company doing work on a subdivision that was the subject of the planning board's review. Neither the applicant, because it's also incumbent on the applicant, when you're taking a look at General Municipal Law Section 80, again, I think it's 803. I'm not gonna bet the farm on 803, but General Municipal Law Article 18, let's just say that. When you're dealing with compensation on matters before an agency, it's not just the public official's responsibility to disclose the fact that somebody might have an interest in an application before a board. It's also incumbent on the applicant, if they know somebody on the board has an interest, to disclose that fact. So anyway, in this case, you've got Keller v. Morgan, and the chairperson of a planning board held a 25% interest in a company doing work on the subdivision. Neither the applicant nor the planning board member had disclosed the fact that this 25% interest existed. And the planning board member voted on it anyway. It came to light that he had this interest, and the town board was like, we're gonna remove you. I suspect that there was probably some politics going on behind with that one too, but who's to say? But the town board decided to remove this planning board member. And the planning board member challenged that, saying that it wasn't supported by substantial evidence. And the court said, even though the planning board chair didn't know, apparently very earnestly didn't know that they had this 25% interest with this company that was appearing before them, even though he didn't know, it was still grounds for the town board to remove him. So he not only violated the compensation on matters before an agency, in my mind, this isn't all that different from, let's say, the town of Gardner case with the steel supply company, or the town of Tuxedo case with the advertising company, right? You have somebody with a financial interest and could stand to gain financially from an application before the board. I think you're delving strictly into common law conflict of interest areas. It just so happens that this case talked about it in terms of compensation on matters before an agency, but really that provision of GML Article 18 is supposed to be for things like a planning board member, again, being an architect. Don't be an architect on a project before the planning board. Do it in the next town over, okay? Just don't do it in your own town. Dual office holding, and let me check my time. Okay, I think I might end on this topic because I know I'm not going to get through conflicts of interest on contracts. That could go. I really just put that in case I didn't have enough content to fill the full hour and a half. So don't worry that we're not going to cover conflicts of interest in contracts. And if you're really super interested in it, we have a webinar with my hand gesticulations and all of that available on the Association of Towns members only website. Dual office holding. This is also something that comes up with planning board in the context of planning and zoning ethics. When one person can hold two offices. There's no general prohibition against one person holding two offices. However, there are 3 different situations where those 2 positions could be considered incompatible. Number 1 is if a position is subordinate to another. So position A cannot be the boss of position B. A second way of being incompatible is if there is a conflict of duties. I like to think of this as upsetting a system of checks and balances, or like your responsibilities are so inherently at odds that one person could not reasonably be able to do them. Like you would have to constantly keep recusing yourself because it's just not workable. And then otherwise prohibited by law is if there's a statutory prohibition. An example of a subordinate position would be a town board member also working in the highway department. The town board has the authority to set the salary of the highway laborer. Therefore, that would be considered being the boss of, even though the highway superintendent is the one who actually has the appointment authority and picks who's going to have that position. The town board sets the salaries and the terms and conditions of employment, so they're considered to be the boss. So town board member, position A, is the boss of position B. No good. Those 2 positions are considered incompatible. Conflict of duties. Again, I like to think of conflict of duties as upsetting a system of checks and balances. I think it's probably the easiest way to think of it. So let's say that you have a code enforcement officer who's also on the Zoning Board of Appeals. If you're on the Zoning Board of Appeals, you know how this works, right? The code enforcement officer denies a permit, right? They're not the ones who are making the interpretation. They're not supposed to. The default is supposed to be denial, right? And then the Zoning Board of Appeals does the interpretation. So if you have a code enforcement officer essentially reviewing his or her own denial by sitting on the Zoning Board of Appeals, that's where you have a conflict of interest, right? That would be upsetting us. You're reviewing your own work. So that's an example of an instance where those 2 positions would be considered incompatible. The third, otherwise prohibited by law, is if there's a statutory prohibition. Under Town Law Section 271, it says that planning board members cannot also be town board members. Town Law Section 263. Town Law Section 260-something says that you cannot be on the town board and also be on the Zoning Board of Appeals. There's not a ton of statutory prohibitions, but there are a few littered throughout the law. So if you're not sure, call the Association of Towns, call NICOM, call NISAC, talk to your town attorney, just double check. As I said, not a ton, but there are a few out there. And then there's a few really random ones, like in education law, where the supervisor can't also be on the school board, and you're like, that's weird. weird. So there are these random ones that exist. So just double check on that. Yes, question.
What about a planning board member serving also on the ZBA?
Oh, I knew somebody was gonna ask that question. So the question was, what about a planning board member also serving on the ZBA?
Or vice versa?
Or vice versa. So there's not a clear opinion on this. There's no agency opinion on this. And I'm going to give such a lawyer answer. It's going to be so annoying. It depends. Because planning boards don't have any inherent statutory responsibility. The town board gets to determine what the planning board is going to do, right? What their responsibilities are going to do. They also have the authority to impose some responsibilities on the Zoning Board of Appeals. Granted, the Zoning Board of Appeals has statutory responsibilities. They're in charge of variances and interpretations. But what I'm really getting at is that there's some flexibility here with the responsibilities. So you could have an instance where, let's say that the town board gives advisory authority or the first look to the planning board and it's okay, on gravel pit permits, all right, those are popular. On this gravel pit permit, we're going to have the planning board issue an advisory opinion and then the ZBA makes the final determination. Does that sound crazy? Yes. Is it legal? Yes. They could actually structure it that way. If it's something like that, then you are essentially reviewing your own work, and one person would not be able to sit on both the ZBA and the planning board. Because, again, the planning board has the advisory opinion, and then the ZBA has the final say. So if one person is on both the planning board and the ZBA, they're essentially reviewing their own work. What if it's a normal planning board ZBA type situation and there's no, holy cow, I'm sweating, oh my God. There's no review, there's nothing like that, then yeah, I actually don't see any reason why one person couldn't serve on both the planning board and the zoning board. I know people have differences of opinion on that, but especially in smaller communities, especially in smaller communities, it can be hard to staff both a zoning board and a planning board. Yes.
I just went to class on that just before this one on serving planning and zoning combining board.
Uh-huh.
And they said if you do that, and they're on board for it, but there's an application, so you need a variance, and then you need to do the site plan or a special use permit.
Uh-huh.
That person, if they're on both boards, can only vote on one or the other.
Okay, so
They can't vote on the variance and then vote on the approval of the.
okay, yeah, that makes
That's what they kind of told us.
yeah, no, that absolutely makes sense. So there was a class beforehand about combining planning and zoning boards, and again, I know that that's actually a pretty common practice, and that's one of the reasons why I'm yeah, one person can sit on both boards. But if you combine the planning and the zoning board, the suggestion in the other class was you should only vote on one thing. So if it's a variance, you should vote on the variance, but not on the other part. Yeah, like a special use permit.
You could vote on both.
I'm going to end on this beautiful picture of snuggling animals. And why I have this here is because they are overcoming conflict, all right? They're overcoming incompatibility. So there is an opinion from the Attorney General's office that says you can overcome an incompatibility of office issue by adopting a local law if it is in the best interest of your municipality. My recommendation for this would be advertise for the position. Either nobody qualified is going to apply or just nobody is going to apply, period. Advertise for the position again. Nobody qualified is going to apply or nobody's going to apply. And then you have a rational basis, a good explanation to say, hey, it is in the best interest of the town that we supersede this incompatibility of office. So when that gadfly comes to your office, comes to your meeting and says, why are you on the town board and also the dog control officer? Why are you the planning board secretary and also on the planning, whatever, a bunch of different situations, that your municipality has a record that you can point to and say, here is why we made this determination that it is in the best interest of the town. And with that, I'm going to go put on more deodorant and let you guys go. Is that what your dog looks like?
Yeah.